You can't just say I'm young and dumb, so I keep getting write-ups. I don't disagree that you're young and dumb, but this is ridiculous. Like, I mean, you thought you were pretty bad breaking into a cop's car, didn't you? That is some nerve.
I'm not in the habit of begging, but on behalf of this community, I'm begging that you sentence this defendant to prison. The message that needs to be sent to this defendant and his circle of friends and anybody who would want to be like this defendant is that if you pick up a gun with the intent to commit violence, you're gonna pick up a 15, 20, 25-year prison sentence.
Sentence you to a term of 25 years in the institutional division. All right, sir, you're Bryce Thomas, and Mr. Thomas was previously in court, entered pleas of guilty in cause number 24 DCCR 0389 to the third-degree felony offense of prohibited weapon. Cause number 24 DCCR 0390, also a third-degree felony of possession of a prohibited weapon. Cause number 24 DCCR 0391, pled guilty to the state jail felony offense of theft of a firearm. Cause number 24 DCCR 0392, pled guilty to the lesser offense of indecency with a child by exposure, also a third-degree felony. There was no plea agreement. I have received and reviewed the pre-sentence report. Has everyone had an opportunity to review that report?
State action.
In addition, there is also the largest packet I've ever received of jail incident reports in a case. Did everyone have an opportunity to review those?
Yes, I took an evening and
35 pages.
I reviewed them one evening.
State reviewed all 35 pages of the
In addition, the state has filed a state sentencing memorandum. Mr. Burbank, did you receive that and were you able to review it? Okay. Anything else, any objections or corrections or additions to the report?
No, Judge.
All right, Mr. Burbank, you may proceed.
Your Honor, this is a very young kid that in a very short period of time kind of stepped off the cliff and got himself in a lot of trouble. I will represent to the court when I was engaged by his family. One of my issues was the recovery of the weapons because they were law enforcement weapons. I will represent to the court that almost immediately, mysteriously, weapons ended up in my office in the front hallway and were returned to the sheriff's department. And I'd like the court to take notice that those weapons are off the street and back into the department.
Could you speak up a little bit, please?
Oh, back into the department. The would go open because I do not have a recommendation. You can place him on probation for a period of 10 years and see what he does. These are third-degree felonies that you can do. At the very end, state jail judge, I believe, the theft of the firearm. You could put him in a state jail for a period of time and put him on probation for the other one. I would ask that if you are going to send him to the penitentiary, that maybe in reference to the sexual offense, that you do place him on probation so that you can have some accountability for him once he got out for a period of time. That would give the court maybe whether or not he's learned his lesson. Now, as you peruse through the 35 pages of incident reports, and I'm not trying to be funny, because I've talked at length with Mr. Thomas about those, and he'd like to address the court on those. It is what it is, and that's not behavior of whether or not he would be able to follow the court's orders if you can't follow what's going on in jail for a period of time in reference to probation. I would ask that the court would ask Mr. Thomas.
Yeah, go ahead. You have something to say?
You don't have to say that. I could just say I was just young, dumb, you know, just being in jail at a young age and not really knowing that. I got write-ups.
Yeah, but once you get several write-ups, I mean, the whole point of growing up is to learn from your mistakes.
Yes, ma'am.
So if you keep getting write-ups, then you can't just say I'm young and dumb, so I keep getting write-ups. I don't disagree that you're young and dumb,
Yes, ma'am.
but this is ridiculous. Like, I mean, I know our jail cannot wait for you to get out. Cannot wait. Mr. Coleman?
Yes, Your Honor, I'll be brief since I put everything, I made the state's position clear in our sentencing memorandum. I'd like to briefly shift the focus from the write-ups to the underlying facts in this case, which
Yeah.
I believe are.
Still in out of cop cars.
Stealing from patrol vehicles, at least 2 patrol units, Your Honor. Detective Matt Dixon is here if you want to hear more details of the detective. But Your Honor, I think the audacity, the boldness to steal these weapons from a police car goes to show what exactly the nature of this defendant is and what we're dealing with here. And even more than that, Judge, it appears from the underlying facts that the defendant may be implicated in a series of other car burglaries. We've got a Glock switch that converted one of those weapons into a fully automatic weapon. He was conspiring with another juvenile, a 16-year-old, to steal the weapons, which a photograph is attached to my sentencing memorandum if you've seen it. This was nothing less than an arsenal that these kids amassed, Judge. I shudder to think what could have become of these weapons if they would end up in the hands of other criminals, if they could have been used against law enforcement, Your Honor. Long gone are the days where there's a low caliber Saturday night special that these kids use, you know, in some type of a crime. They are loaded for bear with fully automatic weapons. I'd ask the court to make an example out of this defendant. He benefits from not having a criminal history to speak of, but Your Honor, this is beyond the pale. I ask you to send him, do 2 things, a split sentence in this case. Sentence him to prison for what he's done, and then following that, a consecutive probation period so that we can continue to monitor him and supervise him after he's released from prison. Thank you, Your Honor.
So I wanted to make sure, Mr. Coleman, I've done this type of sentencing that you're asking for on some different cases. I think the probation period, if I sentence him to probation today, I don't know that I can make that consecutive. So I think
I believe you can, Judge, and if you need to recess this proceeding, I can get you case law in pretty short order. I think you can.
because when would it start?
It will start after he finishes his period of incarceration.
Okay. So whatever I give him, if I do prison, and then I say it's consecutive with a probation, and does it matter if it's a straight or a,
I don't believe so either, Judge. But again, I'm happy to get you some case.
No, I appreciate the idea. Again, we've done it sometimes. I mean,
Yes, ma'am.
what are y'all doing? What are you doing with all these?
In Texas, a judge can
Not shooting
sack
people.
Sir?
Not shooting people.
Not shooting people yet. What are you shooting? Why would you have these? What are you getting these to shoot at? Just to be tough and say you have guns?
No.
That's all that's happening with these guns on the street is y'all are shooting at each other, at other people, at houses, at cars, at whatever. There's no reason to have these kind of guns. These aren't hunting guns, right? You're not going to shoot a deer. Do you hunt?
I do.
Do
I
you?
have before, but
Have you?
yes,
Which one of these is your hunting gun?
none of those.
You thought you were pretty bad breaking into a cop's car, didn't you? That is some nerve. I mean, seriously, you're the second person I've had in 11 years that has had the nerve to do that. Here's what I'm going to do, because I agree with Mr. Coleman. I would like, at least in the indecency case, to get treatment and probation on that case so that we know you're not going to go make that type of bad decision again. But I'm not giving you probation on everything. You're going to you want to change your life and do better and not be young and dumb, you're going to have some time to figure that out. So in cause number 24, DCCR 0389, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a prohibited weapon. Mr. Coleman actually asked me to sentence you to 5 years. I don't think that's enough. I'm going to sentence you in that case to 7 years in the institutional division of the Texas Department of Corrections. You'll receive credit on that sentence for any time you've been in custody. And part of the reason I made it lengthier is because you have been in custody so long, and a 5-year sentence really isn't going to amount to much. Cause number 24, DCCR 0390, also find sufficient evidence to find you guilty, and at this time find you guilty of possession of a prohibited weapon. Sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24, DCCR 0391, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of a firearm. Sentence you to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Then in cause number 24, DCCR 0392, find sufficient evidence to find you guilty. However, in that case, I'm going to defer all proceedings, place you on probation. No, that's the third. I'm going to find you guilty of that offense, sentence you to a term of 10 years in the institutional division, but I'm going to suspend that and place you on probation for 10 years.
Can I address the court on that?
Mm-hmm.
With the deferred, though, with the registration, it would, if he did comply after he got out, that he may have a chance instead of a conviction.
He's already got 3 convictions.
Well, I
A fourth.
understand that, but a sexual kind of.
May I respond, Judge? That is a reduced plea to a reduced charge.
I agree.
I point that out.
Can I give a straight on indecency though? Hold on.
Okay.
I think it has to be deferred. Hold on. Yeah, it has to be deferred. Okay, so I'm going to go back in that cause number, which ends in 0392. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings, and I'm going to place you on probation for 10 years. That will run consecutively to the other cases. So that probation does not start until you get out of prison. Then, if you violate that probation, you could be sentenced up to 10 years in that case. So you're going to be under supervision or in custody for a very long time. So if you really want to change your ways, you're going to have every opportunity to do that. If you don't, you're going to end up, number one, you're probably not going to make parole if you keep acting like you've been acting here. If you get to prison and you act like this, you're not going to make your parole. You're going to do that whole 7 years. That's going to be up to you. The sooner you get out and act right, the sooner you can start this other probation and get off of it, grow up, and maybe change your life. That's going to be up to you. On that deferred, I am going to order a $500 fine that you follow all of the conditions of probation. That's going to include sex offender treatment, going to whatever classes are necessary, staying clean, not getting in any trouble, all of those kinds of things. Do you understand? Mr. Coleman?
Your Honor, is there a deadly weapon finding option with these weapons?
I don't think so.
You don't think so? Okay. Okay.
Unless you can, I don't think that's,
We didn't allege it.
well, and they're not, possession of a prohibited in the 3G, so I don't think we can.
Okay.
Yeah.
I'm sorry.
All right, so all of these are actually wrong because y'all marked off plea bargain and there wasn't a plea bargain. So I'm going to hand you the trial court certification in all of your cases. This shows that these were not a plea agreement.
It was a plea agreement, Judge, because there's a, no.
Oh, because of-
No, there was an unauthorized use that we agreed would be dismissed.
And also the lesser offense in that, so there was consideration taken, so this was an agreement, at least for those reductions. Okay, so you have waived your right to appeal. In these cases, I'm going to hand you those certifications. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank. All right, good luck to you, sir. You can go back with the bailiff.
Yeah, I appreciate it. I'm just on that different strengths where it's reasonable.
Good morning. Are you Caden
Yes.
Fontanet? And this is 25 DCCR 1759. Mr. Fontanet was previously in court, entered a plea of guilty to the first-degree felony offense of aggravated robbery. It was an unagreed plea. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor. The state has, Judge.
Are there any additions or corrections to the report?
Not from the defense. Not from the state, Judge.
And Mr. Coleman, you said you have a witness or some evidence?
Actually, Judge, Mr. Rojas has graciously stipulated to the admission of the surveillance video from the convenience store in question. So I
Okay.
don't need to call my custodian record. With the court's permission, first of all, I'm offering states one.
No objection.
Make that states two, because this one was the plea admonishment
Okay.
documentation, please.
I'm offering states two.
No objection.
States two is admitted.
Permission to publish, Judge.
Yes, sir. Any other evidence, or witnesses?
So just brief argument if I may.
Any other evidence or witnesses for Mr. Rojas?
No, Your Honor, just like,
Mr. Rojas, you may make argument first.
thank
Go
you,
ahead.
Judge. And obviously, after seeing that video, it makes what we're asking for harder to do. And what we're here asking for this morning, Judge, is probation. Mr. Fontainet's defense, he is a young offender. I know the court is tired of hearing the same story over and over, and young guys with guns in here. He's got a limited criminal history. I believe this is his first felony. He's never been on any kind of felony supervision or felony probation. Unfortunately, he's just fallen into the same situation that we see so many other youthful offenders fall into. He's got no direction in life. He's very little support at home. Sees no way out of the situation that he's in, so he goes and decides to rob a store and get some money. Did the wrong thing. And if his story in the PSI is to be believable for what I believe is the right reason, he's trying to help his mom out at home, he's trying to pay some bills, keep the lights on. Certainly, there are better ways to go about doing that. And I hope that the time in jail has taught Mr. Fontanet that. We've got options here, Judge. We can send him to prison or we can put him on probation. Certainly, he's on the road if this conduct continues, he's on the road with prison. I don't know that the day is the best time to make that exit for him. He's got a long life to live. We can send him to prison. He can be there for a few years and come back out. I don't know that he's going to get the help that he really needs in prison. There are programs available on probation that if he's serious about turning his life around, like he says in the PSI, those programs can help him. And if he does take advantage of those, it in turn would make the community a little bit safer. Because there'd be one less guy running around with a gun when he does get out of prison, if that were the road that you chose to take. Planning on living at home with his mom. I think he has some younger siblings there. To his benefit, before he was even arrested, he started a GED. I think on the night that this happened, he had just finished a GED class and made a dumb decision to go hang out with these guys that he should not have been hanging out with, and did this robbery. Again, Judge, you've got two options. You can send him to prison, or you can try to get him some help on probation, and hopefully he will take advantage of that. And certainly if he doesn't, we're going to know pretty quick, and you'll have another chance to send him to prison probably for a longer time.
All right, thank you. What is the status of the other two? Are there co-defendants? Have they been charged?
They have been charged, Judge, and I have both of their cases, Judge.
And they have not been sentenced yet or
No,
anything
Judge.
like that?
No,
Okay.
Judge.
All right, go ahead, Mr. Coleman.
Yeah, I'll be brief. Whether it's the Pine Club Apartments or Rogers Park or a Speedy Mart, you've seen this, and we've seen this in this community all too often. I'm preaching to the choir, Judge. Prayer vigils and advisory committees, all that stuff's fine, but you judge where the rubber meets the road. You are that person that can protect the community from somebody like this defendant. You are that person that can either let him walk out of this courtroom on probation with a piece of paper with conditions and promises that he won't resort to this kind of violence that you saw on that video, or you can ensure that the community is safe by putting him behind steel bars, concrete wall and razor wire fence. Uh, Judge, I'm just asking, I'm not in the habit of begging, but on behalf of this community, I'm begging that you sentence this defendant to prison. The message that needs to be sent to this defendant and his circle of friends and anybody who would want to be like this defendant is that if you pick up a gun with the intent to commit violence, you're gonna pick up a 15, 20, 25-year prison sentence, Judge. And I'm just asking that you do this on behalf of people who live at the Pine Club apartments, who just want to live in peace, people who want to go take a walk at Rogers Park and not be robbed, and somebody that wants to stop at a Speedy Mart convenience store and pick up some snacks without becoming a victim of a robbery. That's all I have, Judge.
Thank you, Mr. Coleman. So, Mr. Fontenette, there was a time some years ago that there really wasn't even a question. State's attorneys were recommending youthful offenders, probation. Let's give everybody an opportunity. And things have just changed in such an incredibly dangerous way with young people doing what I just saw you do on that screen. I cannot imagine the fear that person had that was working in that store, that he now has, just trying to go to work, make a living, and go home. And he has 3 people come in and not just grab a little quick something and run out, but terrorize him for quite some time. Pulling him around, yanking him around, putting guns in his face, all 3 of you. I also, in addition to the PSI, get jail incident reports. And you apparently like to fight and jump people, which is what's been happening in the jail. So it makes it very difficult for me to go, oh, this is somebody that's going to get out and behave, who can follow the rules, because you can't even follow the rules in jail. And the pre-sentence report shows that you're a high risk level, which tells me that after they've looked at everything, that you don't have, unfortunately, a good likelihood of being successful if I were to put you on probation. And Mr. Coleman's right. We're tired of it. And there's got to be something done. So in cause number 25, DCCR 1759, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. And at this time, I'm going to find you guilty of aggravated robbery. I'm going to sentence you to a term of 25 years in the institutional division. I'm going to sentence you to a term of 25 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. This was not an agreement. You have some rights to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You can talk to Mr. Rojas about any questions you have about that. I am making an affirmative finding of a deadly weapon. Mr. Fontenette, I understand that this is harsh, and I know you believe this is harsh, but I think this is necessary. I hope that you go and you make things right. You can get out of prison. You're still going to be young, and you can make your life better.
This one, Judge, and just so you know, the court, we brought him down here from Minnesota. He's also serving time up there. He wanted to come back and resolve these.
Okay. Perfect.
That's the
Thank
reason
you.
to try to wrap them all up today.
Thank you. All right, sir. Are you Jesus Marin Garcia? And Mr. Parker, will your client waive the formal reading of the indictment?
He will, Judge.
Mr. Garcia, in cause number 24, DCCR 0586, you're charged with a third-degree felony offense of unlawful possession of a firearm by a felon, and that's from July 14th of 2023. How do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker? Speak up, please.
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenors number one.
No objection?
It's admitted. Is there any evidence that Mr. Marion Garcia is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon, sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will sign a dismissal when it comes through in clause number 24 DCCR 0587 as part of this agreement. It will also run concurrently with any case that you're currently serving in Minnesota as well. All right. I'm handing you the trial court certification. That shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this, but I'm required by law to read it. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can ask Mr. Parker. All right, good luck to you, sir. Thank you.
Judge, I think they filed a motion to dismiss it on leave. I don't know if you got it.
Already signed. Mr. Harrison, in cause number 24 DCCR 0544, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation November 19th of 2024 for the first degree felony offense of aggravated robbery. And that was a 10-year deferred probation. Is that correct?
No.
The motion alleges that you violated your probation. Count one alleges that you failed to report as directed on or about March 31st of 2026. Is that true or not true?
True.
Count two alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
True.
Count three alleges that you provided a urine sample June 24th, August 27th, October 30th of 2025, and March 9th of 2026 that tested positive for tetrahydrocannabinol. And is that true or not true?
Your Honor, I can abandon 4, 5, and 6. We can skip to 7.
Count seven, let's see, state abandons 4, 5, and 6. Count seven alleges that you committed the new offense of failure to identify a fugitive or give false information on July 13th of 2025. And is that true or not true?
True.
Count eight alleges that you associated with a convicted felon and disreputable person on July 13th of 2025, and that you were stopped by the Port Arthur Police Department with Gerodrick Randall, a convicted felon, and that he fled on foot while possessing a weapon. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 3, 7, and 8 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
Well, give me just a second.
Your question would be the underlying offense, Your Honor.
I'm just going to go back and look at the PSI real quick.
He was one of 4 individuals that were breaking into cars. When they got caught, one of them fired a shot at the person who confronted them while they were breaking into cars at a parking lot. Put everyone on probation. They've all come back, Josh.
I guess my concern is that there was obviously a gun and a shot in the underlying offense.
I do recall Mr. Harrison not being the shooter. I think we were able to figure out who.
That he's in another gun? I mean, another car with somebody
Yes.
with another gun?
And Mr. Randall's been revoked and sentenced to 8 years. He had a drug case, a new felony, so which is why his was a little bit more.
Look at something else. Do you happen to have the PC for that? The new,
For his new event,
Bid ID.
yeah,
I do, Judge.
thank you.
I also have the report from Mr. Randall's charges from the same stop. If you're asking as far as where the gun was.
Yeah, that's
Mr.
what-
Randall's lap as he ran from the vehicle and fell out as he ran.
Obviously, I'm just having some concern.
I understand her.
Yeah, obviously, we're all over. Can't tell you how over we are with guns. And the fact that this is the second out past curfew with in a car doing whatever you're doing that you shouldn't be doing with another gun.
I will state, Judge, it was at about 6 o'clock in the evening. I don't think it was past.
Oh, it was? I'm sorry. I thought I read
It was-
something
it's-
about curfew. That was
Not this one, Your Honor.
okay. Thank you, Mr. Nick. I don't guess it really matters what time it is. And the other three that have already been revoked.
Mr. Randall received 8 because he was in possession of a firearm.
So was he one of the original
I think so, Judge. I do know that.
co-defendants under the underlying case as
I
well?
believe that's why he wasn't supposed to be hanging out with him. And then,
That would probably.
there's
It'll have in here.
yes, Your Honor, he's one of the original.
Okay, I'm
One
not
of the
gonna,
co-defendants.
yeah. Five's not, I'm not gonna accept 5. Not if you're already on probation with the same person for aggravated robbery with 3 guns in that car, another gun in this car. If he got 8, then I would consider that, but at this point,
We'll discuss it.
I'm over all of this gun stuff. So I'm gonna, I'll keep, I guess, the paperwork for now. If y'all come up with an agreement,
Yes.
otherwise it's a motion to revoke. I don't have to accept any agreements. It can just be up to me and we can have a hearing if we have to. But I'll just keep it for now. I can make an adjustment if you guys come up with something different.
Okay.
All right.
Thank you.
Goodbye. With Mr. Kenneth Harrison and 24 DCCR 0544. Mr. Harrison had already entered pleas of true to counts 1, 2, 3, 7, and 8. And you guys have visited, I guess, about my unwillingness to accept the plea agreement and if you come up with some other agreement.
Yes, Your Honor, we have
And what is that?
for 8 years.
And Mr. Harrison, is that your understanding and is that your agreement?
No.
And so with everyone's permission, can I make that modification on the agreed punishment
Your Honor, he
recommendation?
said no.
You said no?
Yeah.
Oh, I thought he said yes.
I said yes, ma'am.
He said yes.
I heard it wrong.
Sorry about that. It's scary.
That's okay. So, can I make that modification on this document?
Yes, ma'am.
Okay. So I have, here, Mr. Harrison, on the tablet, some documents that have your signature on them. I've made that change to show that the agreement is for 8 years instead of 5. Before you went over and signed these, did you go over them with Mr. Lewis? Do you fully understand all the documents you signed? And do you understand, if I follow this agreement, that you will be waiving or giving up any right to appeal? State tenders number 1.
Location.
It's admitted. Is there any evidence that Mr. Harrison is not competent?
No.
All right, sir, I'm going to find that you entered your plea of true to counts 1, 2, 3, 7, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with that agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. I am making an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or how long that lasts, you can talk with Mr. Lewis. So, Mr. Harrison, in my opinion, you're getting a great deal today. You could have gone to prison today for anywhere between 5 years and up to the rest of your life. And I know you've probably been hearing out of the jail what's been going on with the cases where people have guns and are continuing to use them and possess them. So take advantage of the time that you have, do something better with your life. And when you get out, don't possess a gun. Don't be around anybody that's possessing a gun, because if you are and you're here in Jefferson County, it's going to be a whole lot worse than today. Do you understand?
Yes, ma'am.
All right. Good luck to you. You can go back with the bailiff. You'll get credit for any time you've been in custody.
Judge Raquel West delivers a shocking 25-year prison sentence to a teenage robbery defendant, leaving his family stunned as the courtroom takes an unexpected and emotional turn.